All right, so that's what happened yesterday at the court. We now want to link up with my colleague Rita Tnina, joining us live and direct from the Supreme Court. Rita, good morning. Now, this particular session was supposed to start at 9, but we've seen, this sort of lateness before. But even apart from that, what are we looking at today? Yesterday, a number of, decisions were made with regard to some of the applications that had been made by the petitioners. What are we looking at today as we await the start of the session?
Well, good morning to you, Betty. Once that session kicks off, it was meant to start at 9, as you mentioned, so any minute from now it should be getting underway. And President Uhuru Kenyatta, through his lawyers, a team of lawyers led by Fred Ngatia, will be the first to make their submissions. Attorney General Githu Muigai, who was then joined as an interested party, as well as a Kuruau court. He was a presidential candidate in the August 8th and the October 26th elections. They will also be making their submissions. The court will also receive a report of the scrutiny of the results transmission forms. As you mentioned there, Betty, yesterday, the court made a ruling. One of the second petitioners, Njonjo Mue and Helef Khalifa, had sought several things from the court. They had sought scrutiny of Forms 34A, 34B, 34C. They had sought scrutiny of the KM's kit. They wanted SD cards. They wanted the KPMG audit report of the voters register. They also wanted the voters register itself. Among the 20 applications that they had made, the court granted them 2. That is, they ordered the IEBC to provide Forms 34A, 34B, and 34C for scrutiny. He also ordered the IEBC to provide a certified copy of the voters register, and that is one thing that caused some debate here in the afternoon. The court made that ruling in the morning. In the afternoon, the IEBC came back and said it wanted 80 million shillings to be able to photocopy 450,000 pages of the voters register. There was some argument here in court on social media as well. Some Kenyans were trying to calculate what that would mean, and some of those who made the math saying 80 million shillings for 450,000 pages would mean that one page would cost 117 shillings. So after that argument here in court, the petitioners then settled for the soft copy, which the IEBC would provide free of charge. So this morning, we're expecting the report on the scrutiny, what the teams found from yesterday. The process continued late into the night, and this morning they will be telling the court what they found out in that scrutiny of the forms as well as the voters register. But yesterday, Betty, the petitioners, Haron Mwao, former MP, as well as the activists Helef Khalifa and Njonjo Mue, through their lawyers, made their arguments. Haron Mwao saying that the election should be nullified since there were no nominations which were held. He argued through his lawyer, Benjamin Musyoki, that the election was a process. It was not a one-day event that the candidates would just turn up and go to the ballot. He says the nominations should have been held. The nominations are the ones that should precede the elections, and that the election was not a continuation of the other one. That is why it was called a fresh election. And so that was his main argument. The argument of Njonjo Mue and Helef Khalifa was based on several things. One of them is the issue of nominations. They also argued that the nominations should have been held. They also argued that the election was not held in accordance to what the law says, that it should be held in a free environment, which is free of violence, intimidation, and corruption. And they cited the issues in Nyanza, the 4 counties in which the IEBC postponed the polls, Homa Bay, Siaya, Migori, as well as Kisumu. And they were arguing that in those areas, there were people perhaps who wanted to vote and who were denied that chance after the IEBC postponed the elections due to violence. They also argued that there was an internal environment, they say, was not conducive for the IEBC, the commission itself, to conduct the elections. And they dwelt for quite a while on 2 things. One is a statement by the IEBC chairman, Wafula Chebukati, to the media on the 18th of October. Another statement by Roslyn Akombe, who resigned as an IEBC commissioner, and they say both statements by Chebukati and Akombe assured that the IEBC was not acting impartially. They said that Chebukati, in his statement, saying that he was under pressure from other commissioners and he was finding that he could not act in a manner that was impartial as he would wish. Remember, he had also in that statement said that he could not guarantee that the commission would undertake a free and fair election. So those were some of the arguments. There was also the argument of the universal suffrage. They argued that in the areas that the elections were postponed in the 4 counties, there were 3,600, just over 3,600 stations in which votes were not returned. And so they were arguing that the requirement that the one who is elected as president should have 50% plus 1, as well as 25% in at least 24 counties, was not as is required by the court. The issue of universal suffrage was not met as is required by the law. The IEBC, in the afternoon, it was the turn of the IEBC, and the IEBC chairman, Wafula Chebukati, through their lawyers for 3 hours, they presented their case before the court. They argued that failure to conduct nominations did not flout any law. They were arguing that no one went to court saying that they wanted to take part as a candidate and they were denied the chance to take part in any nominations since the IEBC did not conduct any nominations. The IEBC also defended its decision, saying it did not cancel the elections in the 4 counties. Instead, it postponed the elections and had sought advice from the Interior Ministry on the security situation there. They presented a letter from the Interior Cabinet Principal Secretary, which said that the security situation in the 4 counties could not be guaranteed.
Right.
And
Rita,
they argued that they were
I have to
working within strict timelines, the 60 days that the Supreme Court had ordered the Commission to conduct elections.
Right.
And so they were saying if they had postponed to a specific date, the things would not have worked as according to the timelines. Betty.
All right, Rita.